I think it was the dope. I blame it on being on drugs and the come down. I barely do drugs, then months go by, then I do drugs. Admitting on multiple occasions, both to evaluators and to law enforcement, about consuming a significant amount of methamphetamine for these offenses, admitting that she and Shad were toking methamphetamine beforehand. She even talks about how she was still tweaking on meth during the dismemberment process. Ultimately, that's what this case comes down to, right? Because as we heard from, I think, every doctor, it's difficult to parse out psychotic symptoms versus drug use. So when we're talking about whether somebody has a mental disease or defect and they're voluntarily ingesting methamphetamine, it's really hard to say that that's due to some other underlying mental health issue, right? And that kind of makes sense in our common sense. But ultimately, that's what this case comes down to. It's the defendant's own words that this was fueled by meth, and now it's, well, no, it's bipolar. It's something else, some diagnosis from way before this offense. And that's not the standard you are to apply. Okay, so first, 2 questions you'll have. Was Ms. Schabusiness suffering from a mental disease or defect at the time of the offense? Not in 2012, not in 2014, not in April of 2021, not in June of 2023 when she's meeting with Dr. Litton, or in July with the other doctor, Dr. Seipel. The relevant question is at the time of the offense. Okay? And I disagree with counsel. And you all sat through Dr. Litton's testimony. I don't think it's clear at all that she's diagnosing the defendant with bipolar 1. She said most likely, seemingly based on the prior diagnosis. But there's never a firm diagnosis, and we heard Dr. Seipel comment on that as well. And you also heard about what bipolar entails, right? What's required? What are some diagnostic criteria, right? We heard about these manic episodes that last a week or thereabout, or even longer, where there's this heightened and manic state followed by a depressive state. You've heard none of that. What part of the interview the defendant gave to law enforcement on February 23rd indicates that she's still going through some manic episode? What part of all of the witnesses and evidence you've heard about the time in the night of February 21st indicates that she's going through some manic episode? You've heard none of that. So this idea that this manic episode arose and dissipated in a flash, just happening to be around the 5 minutes where she's actually strangling him and then the day that she dismembers Shad, it's utter farce. There's no basis for that. Instead, we're relying on a bipolar 1 diagnosis from April of 2021. It's a year before the offense. And you heard from Dr. Seipel and Dr. Engen, both of whom are court-appointed. The state didn't hire them to come. They're the court's appointed experts. Both of them have issues with that initial diagnosis. You heard why, about the concurrent methamphetamine use around the time of the Nicolay admission. And that's the same story we're seeing now, right? It's the same thing. Methamphetamine use exhibiting psychosis, and that's unfortunately what led to Shad's death in this case. It's the same thing. So this concept of a civil commitment and the judge ordered voluntary medication, it's not relevant. It's not consistent with the other evidence you saw in this case. What did you see that led you to think the defendant was going through a manic episode, to have bipolar 1 at the time of the offense? That's what's relevant. You're told what a mental disease or defect is. It's something that substantially affects the mental process. That's something else you heard nothing about, right? People can have bipolar 1 and not have their mental state substantially affected. You heard nothing from Dr. Litton to tie that diagnosis, even if we'll give the benefit of the doubt and say she did diagnose bipolar 1, despite the testimony. You heard nothing to tie that into it being a mental disease or a defect. You're instructed that, as we talked about in opening, it's not just because somebody does something really abhorrent and really awful, unnatural. That's not a mental disease or defect. That would be a perverse incentive to sort of reward people to do more deranged things, right? That's not enough. It's not a voluntarily induced intoxicated state. That's what we have here. Mental disease or defect is not a mental state brought about by the ingestion of a controlled substance. So when we heard about meth-induced psychosis, right? Again, that's something that's being brought about by a controlled substance. Those aren't mental diseases or defects. You're responsible in this state for anything you do because you choose to ingest methamphetamine. That's the law. You heard nothing in this case about there being some permanent condition. None of the doctors diagnosed the defendant from suffering from any brain disease because of methamphetamine use or some other substance. Not even her doctors will say that. So when the defense argues that chronic use of drugs or alcohol may produce a condition that can constitute a mental disease or defect, if the condition has become permanent, nobody is testifying to that in this case. That's not any evidence that you heard. You heard and saw the defendant in the time almost immediately before and immediately after this offense, right? We heard from Dr. Seipel about that, and I think the defense fundamentally misunderstands why the state called Dr. Seipel. Obviously, he didn't do an NGI evaluation. We asked him about that. The relevance is because he highlights flaws in Dr. Litton's report, in her opinion, and that's the sole opinion the defendant's relying on to meet her burden. We heard about why, when you're considering, a bipolar diagnosis, particularly in the NGI context, it's really important to look as close as you can to the proximity of the offense, right? And that makes sense, right? It helps validate if this is actually some manic episode or something that would be throwing a chair randomly at a person, right? But there's a difference between those two things. And we heard none of that. We heard none of that from Dr. Litton, did we? We heard a lot about mental diseases and illnesses that she thinks happened way before, way after. And yeah, she reviewed a lot of material, but Dr. Litton tied none of it into February 22nd of 2022, did she? No testimony about, well, okay, so if somebody has bipolar 1, how is that manifesting? How is that utterly inhibiting the defendant from her awareness of what's going on, or her ability to conform conduct, right? We heard none of that. We heard a statement at the end that, well, I think she's NGI. I would support the plea. And you heard no analysis, right? No analysis of, well, I considered the defendant's actions the night of the incident, and this raised this concern for me. That would support my opinion. We heard none of that, right? And it's their burden to do so. You heard none of that from Dr. Litton. She's, yes, qualified, experienced. We heard about that. But there are real issues with her methodology in this case. Based largely, her opinion is, on her interactions with Ms. Schabusiness on June 19th of 2023. And we heard ample reason why that should be a red flag. People who actually administered personality tests to kind of determine feigning and over-exaggerating of symptoms, including experts hired by the defense, have raised that concern for the defendant, that she over-reports symptoms, that she exaggerates symptoms. And Dr. Seipel is exactly right. And you heard the testimony from Dr. Litton. Most of her opinions based on her interactions with the defendant and this bizarre behavior that she's observing. Incidentally, bizarre behavior you haven't observed for 1 second during this trial. For the last 4 days, there's no throwing chairs, there's no outbursts, there's no staring or off, right? So this idea that Dr. Litton's opinion, based on her interactions with the defendant and some old bipolar diagnosis, there's nothing tying it together. There's nothing showing you that would allow you to agree with her opinion that the defendant had a mental disease or defect on the date of the offense, which is the relevant question you have to answer. You have reported behaviors by Dr. Litton that aren't in any other reports that are observed by doctors. Dr. Seipel meets with her in really close proximity, isn't reporting any of these behaviors. And again, one of the questions you have is capacity, right? Substantial capacity to do things. And there's a big difference between capacity and desire to do so, with volition, with choice, right? The capacity to go skydiving. I don't have the volition to go skydiving. I have the volition to dunk a basketball. I probably don't have the capacity to dunk a basketball, right? Those are different concepts. And the information you heard about in the records from the testimony is that it's something that the defendant can control to some extent, right? There's no outbursts or any of the behavior Dr. Litton's talking about that Dr. Seipel observes, that the court-appointed expert, Dr. Engen observes. None of that, right? To the contrary, you have Dr. Engen doing scientific tests to determine about the validity of some of the observations and determining the opposite, right? And sure, Dr. Litton was under no requirement to do that sort of testing. But when she says she just looked at the prior results and relied on those, well, what she should have been relying on is that the information the defendant's telling her isn't accurate. That's the only prior analysis that we heard about. So again, there's real methodological issues with Dr. Litton's report. Most importantly, none of it ties together with the date of the offense. Her testimony, for the better part of this morning, maybe 2 or 3 questions dealt with the date of the offense, tying it together. Dr. Litton, how are you able to tell this jury that Ms. Schabusiness was unable to conform her conduct, was not aware of what's going on? You heard none of that. She didn't even review the entire video, the recorded interview that you observed, to see firsthand, really close proximity to the date of this offense, what the defendant's behaviors were. She reviewed a transcript. I think she said she may have reviewed 90 minutes of it or something like that. Didn't review the second interview, which incidentally, as you observed, and you heard from Detective Graff, the same behavior, same mannerisms, same lack of outbursts or anything like that throughout this time. Again, this manic episode that is allegedly occurring. You observed that over several days and didn't observe any of that. So that's the concern with Dr. Litton's testimony, and that's the relevance of Dr. Seipel's testimonies. He points out some of these issues. And he interacted with the defendant as well. Didn't observe any of that on multiple occasions as a court-appointed expert. Again, not hired by the state to come in and say that, report that. So you have the report from Dr. Engen, the court's expert. And you heard the testimony, and if you review the report, it jives with common sense, right? There's no mental disease or defect that she talks about. The mental illnesses, which there seem to be, are all substance abuse related. And again, the law of this state says that's not enough. That's not a mental disease or defect. So sure, there's, I think, amphetamine disorders and methamphetamine intoxication. She says, yeah, I would support these illnesses. Those aren't mental diseases or defect. She considered a bipolar I disorder and rejected it for the reasons we talked about. Given the concurrent use of methamphetamine, it seems like the doctors that the court appointed agree that you're using meth. You're not psychotic. Any psychotic symptoms you're exhibiting are because you took meth, not because you have some diagnosis or of a mental disease or defect. So when you're asked the first question, when you see the verdict form, that question should be answered no. You've heard insufficient evidence that the defendant suffered from a mental disease or defect on February 22nd, 2022. Okay. If you answer that question yes, and only if you answer that question yes, do you get to the second question. Second question asks sort of a compound question. As a result of that mental disease or defect, did the defendant lack substantial capacity, again, capacity, to understand the seriousness of her conduct or to conform her conduct to the requirements of law, right? So understanding and conformity are kind of the two things there. So let's talk about that. You obviously heard from Dr. Engen about that, about how she does not support that. She does not believe that she lacked substantial capacity to have either of those two things, right? And her reasoning makes sense, and really it's kind of reasoning you probably would have gotten to without her testifying in some respects. It helps that this expert that the court appointed comes in and tells you that too, but it jives with common sense, right? Because you heard all this evidence for Monday, Tuesday, Wednesday, and today about the defendant's conduct on February 22nd, 21st, and into the 23rd. She's aware of the wrongfulness of her conduct, and she's telling you as much, right? She tells law enforcement, I took these Clorox wipes and I was wiping up, right? Specifically, even accurately remembering it's Clorox wipes and where she put them in the bags. Detective Scanlon on February 28th asks her, hey, we saw some wiping pattern on the floor, and what was going on with that? And she was like, yeah, I was cleaning up. And they're like, well, did you move the bed over? She said yes. And why did she say it? Why did she say she did that? She was covering it up. Right? And that's why we ask those questions about the blood that we saw on the floor under the mattress isn't seeping through the mattress. It's coming because the defendant moved the bed over it, because she's trying to cover up her crime. And now they want you to believe that she's not aware of the wrongfulness of her conduct? She's telling law enforcement, how am I going to get away with this? That was her motivation for dismembering his body for a lengthy period of time after the fact. Hearing footsteps upstairs, worrying mom was going to find him. She's telling you she's aware of the wrongfulness of her conduct, and she's exhibiting action and volition to clean up. Everything you're objectively seeing evidence-wise in this case shows you that she knows exactly what's going on. She even remembers details about this night. And now we hear this professed amnesia in her comments to Dr. Engen about this offense. And you saw the interview. She had every detail down to the T. She could have drawn that entire basement for you from memory. Everything was located. She's telling you where the meth is located, where the dildo is located, what color the dildo was. She's aware of what's going on, even with the meth use. You have her memory of the incident. You're hearing about how she's describing, and you could probably infer from the nature of the offense how blood was going everywhere in the course of the conduct, yet you heard about the condition of that basement, right? It was pretty spotless, pretty clean, especially considering what happened down there. Because she cleaned up. Because she was aware of the wrongfulness of what she did. She didn't just massacre somebody, dismember him, and leave a war zone down in that basement. No, she cleaned up because she knew what was going on. Then you get to the second part, right? If she's able to conform her conduct to the requirements of law. And again, you heard nothing from Dr. Litton to kind of help you with that, right? Like, okay, if I'll accept she has this bipolar diagnosis, well, tell me, Dr. Litton, how is she unable, because of that diagnosis, to conform her conduct on February 22nd? And you heard none of that. To the contrary, as Dr. Engen points out, you have a lot of information to tell you she's able to conform her conduct pretty well. Right? She's employed. We heard about court cases that she was dealing with. We heard about paternity things she was arranging in the time leading up to the offense. We heard about, after the fact, we saw the contact with law enforcement, right? She's ordered to take her hands out of her pockets for officers. She does that. Order to put her hands behind her back. She does that. complying with orders, complying with commands, complying with questions. She's conforming her conduct pretty well, right? She's following the law enforcement's commands. In her interview with law enforcement, for a lengthy period of time, she's conforming her conduct. She's not exhibiting any manic symptoms. She's not exhibiting any psychosis in that you heard about. There's just nothing in this case to show that she's not able to conform her conduct. To the contrary, you heard a lot of evidence that not only did she not lack that ability to conform her conduct, that what she did to Shad was volitional, was a choice. She liked it. She was aroused by it, right? She told law enforcement that. She wanted to do this. She did. Because that was a volitional choice. It's not because she lacked substantial capacity to not do so. It's because she wanted to do so, and she did. You heard about her saying, well, yeah, I knew I was killing him, but, quote, I did it anyway, right? Because that's what she wanted to do. And again, a mental disease or defect is not because you may not have a clear understanding of a motive. I would say you should, but that's not a mental disease or defect. Just because what she ultimately did is in some respects, quite disturbing, it's not a mental disease or defect. You have insufficient evidence to support that. And again, it's not the state's burden to disprove an NGI plea. I think we have, but it's the defendant's burden to convince you of the NGI plea, and they've utterly failed in that respect. We heard about the burden of proof, that it's a reasonable certainty by the greater weight of the credible evidence. And you should be, even though it's not our burden, I would say you should be reasonably certain the defendant's not suffering from a mental disease or defect. Again, it's their burden to convince you that you should be reasonably certain by the greater weight of the credible evidence that she does. It's their burden. If they wanted the court's expert to review documents from 10 years prior, they could have done so. They could have provided those materials. If they wanted, hey, please interview my client again, they could have done so. It's their burden. And they chose not to. There was additional jail records. They could have produced those. And actually, Dr. Engen's comments about that make sense. Her findings and all the objective evidence you have is this is a meth-induced crime, that whether she had a civil commitment a year prior, had, I think, a mood disorder 10 years prior as a 14-year-old, that's not relevant. It wouldn't change anything. I don't understand these arguments about the reports being stale. As Dr. Engen told you, it's a retrospective review, right? We don't really care. You're not asked to decide, does she have a mental disease or defect today? That's not important. The proximity to today isn't relevant. It's the proximity to the offense. You should actually be entirely convinced Dr. Engen's report is the more relevant report. It's closer in time to the actual mental state the defendant had on February 22nd. It's obviously a complex case in some respects, right? It's a serious offense that the defendant was convicted of. It's obviously it's an important case, right? And the defendant has had experiences in her personal life that nobody should have. Losing parents at a young age, it's something many of us deal with, and it's awful to hear about. It really is. But that doesn't change the law. That doesn't change the standard in this state, because there's simply no evidence to support she had a mental disease or defect on February 22nd, 2022. Not only did she not have a mental disease or defect on that day, you have no evidence to say that mental disease or defect rendered her substantially incapable of conforming her conduct or appreciating the wrongfulness of her conduct. You simply don't have that evidence here. You have ample evidence to the contrary. The defendant is telling you that meth made her do this. She's repeatedly told that to law enforcement. Every objective piece of evidence you have in this case supports that finding. And it's simply the case that that is not enough in this state. That's not a mental disease or defect. So don't let her now try to come in and say this was some other thing. That no, now the meth really didn't have anything to do with it. It's important to note a meth-induced psychotic state is also not a mental disease or defect, as you'll read in the instruction. There's no mental disease or defect. There's no lack of awareness. There's no inability to conform your conduct. You have ample evidence to the contrary. And that leads to one inevitable result, is that she's responsible for what she did to Shad on February 22nd. As a result, you should answer both questions no, or answer the first question no, and don't get to the second question. Thank you.